All right. Good afternoon, everyone. Good morning, depending on what part of the world you are joining from. I have the distinguished honor to welcome you to this very, very important session where we'll be discussing encryption and the implications for digital rights in Africa. Uh, we are honored to be joined by in this session by Commissioner King from the African Commission on Human and People's Rights, and we have also very distinguished panelists who are going to be speaking on the session, but I'll come back to introduce them later. My name is Adiboye Adegoke, and I'll be the moderator for this session, which I believe is going to be a very interesting and insightful session. And before we go into it, please permit me to quickly speak to the code of conduct for the Forum on Internet Freedom in Africa 2021, especially for those who are probably just joining for the first time and who may not have had the opportunity to have come across the code of conduct. I think it's important to draw our attention to the code of conduct. If you go to the event website, you will see it there. I will not be able to read everything, but just as a guide, especially so that we can have a very engaging session, it is very important that if you have a question that you should signify by raising your hand and also by using the Q&A tool that is provided, especially for those who are joining from the Zoom link. Also, if you are watching this live on YouTube or any other streaming platform, feel free to drop comments in the chat box. And as much as possible, any comment that is brought to my attention that I think would help or drive the conversation, I'll be more than happy to point the attention of the panelists to it so that we can get maybe more views and perspective on your comments or question. Also, if you have the mic at any time, and this is for the panelists and for anyone who might be asking questions at one point or the other, make sure that you speak very clearly and at a very moderate pace. This is because there is interpretation going on and sign language so that they can be able to cope with the speed. Also, please be an active listener, be patient with other participants who are speaking a second language. Also, please avoid as much as possible jargons and unnecessary languages. Also, please do not attack anybody. Everybody have the right to their opinion. If you have a counter opinion, please present them as as gentlemanly as possible, and do not attack personality or individual. Let us address ideas and not individual. It is okay for us to disagree. We can always disagree to agree. And we believe that every fruitful conversation, it's okay to have disagreement. And if you are not convinced by or hold a strong position against a solution or intervention by another person, you can explain why and propose an alternative and allow the audience to make a decision on what they think is the most acceptable position. There are also some unacceptable behavior that have been communicated via the code of conduct. As I said, I will not be able to read everything. Please go to the event website right now and read everything where you would see what you cannot do, like unsolicited photography or recording, stalking, intimidation, sexual images, and all of that. Thank you very much. So let me get back to it and go straight with my first task, which is to introduce the session. And after introducing the session, I would introduce one of our special guests to give an opening remark. Let me go to the introduction of the session. So this session basically is a research dissemination panel, which is based on CIPESA's newly published research, mapping and analyzing privacy laws and policies in Africa, the lessons that have been learned and what it means for digital rights. I think at some point during the session, we will also be sharing a link to the research, the report, so that those who are interested in reading more about this research can go and read more about it. And also, our panelists would help us in deep diving into this research during their intervention. So I'm not going to do that. I just want to quickly also speak to one of the expectation of this session. We hope that by the end of this session, that we will be able to, agree on what to do next, how actors you engage, what are the implications of the issues identified. We hope that we'll be able to identify areas where various actors can initiate or support relevant interventions on the continent. And we aim to start a conversation towards influencing and prioritization of right to privacy within the African human rights system, identifying mechanisms to push back against the adoption of legislation and policies undermining privacy-related rights. I think it's time for me to get out of the way and allow the panelists to do their job. But before the panelists come on, I would love to introduce distinguished Commissioner Jameson King from the African Commission on Human and People's Rights, who will be speaking, giving us an opening remark before we go into the conversation. Distinguished Commissioner, you have the floor.
Thank you very much, Boye. Good morning, good afternoon, ladies and gentlemen, distinguished participants. It may be good afternoon where you are. I bring you warm greetings from Sierra Leone. Allow me to introduce myself. My name is Jamesina A.C. Leonora King, and I'm a member of the African Commission on Human and People's Rights, which was established to promote, protect, and interpret the rights enshrined in the African Charter on Human and People's Rights. Additionally, I am the current Special Rapporteur on freedom of expression and access to information in Africa, which is a special mechanism of the Commission mandated to promote and protect Article 9 of the African Charter. At the outset, I wish to thank the organizers for convening this forum and for extending an invitation to me to give opening remarks during the panel on encryption trends in Africa and implications for digital rights. Ladies and gentlemen, encryption can be defined as, and I quote, the ability to encode communications or information or data so that only the intended recipient can read or understand them. Simply put, encryption keeps our data secure, protects us from fraud, and allows us to communicate privately. Therefore, whenever we shop or bank online or chat using instant messaging, we are using encryption. Whereas the use of encryption in digital communications is an essential aspect in the enjoyment of freedom of expression and privacy, especially online, it is important to recall that while the right of freedom of expression as enshrined in Article 9 of the African Charter, privacy is not explicitly recognized as one of the fundamental rights and freedoms enshrined in the Charter. In its resolution on the right to freedom of information and expression on the internet in Africa, the Commission recognized that privacy online is important for the realization of the right to freedom of expression and to hold opinions without interference, and the right to freedom of peaceful assembly and association. Therefore, one can observe that even in a resolution adopted as recently as 2016, the Commission did not specifically refer to privacy as a right, which state parties had the responsibility to promote and protect. Rather, it observed that privacy enables effective implementation of the right to freedom of expression, an enabling tool. There has since been a significant development towards recognition of privacy as a right, at least from the perspective of the Commission. When the Commission adopted the revised Declaration of Principles on Freedom of Expression and Access to Information in Africa in November 2019, specific reference was made to the right to privacy within the context of freedom of expression and access to information on the internet. And this can be found in Part 4 of the Declaration. Specifically, Principle 41 provides that, and I quote, everyone has the right to privacy, including the confidentiality of their communications and the protection of their personal information, end of quote. Furthermore, in addressing state responsibilities, the Declaration specifically introduced 3 principles on privacy. the scope of the right to privacy, privacy and communication surveillance, and the basic requirements of legal frameworks on privacy. The soft law provisions introduced in the revised declaration represent a step forward towards recognition of the concept of the right to privacy, particularly among African countries. However, increased effort needs to be made to raise awareness both on the right to privacy online and the need for encryption to enforce this right, in addition to other human rights such as freedom of expression and association. Ladies and gentlemen, this panel discussion today undoubtedly presents me with the opportunity to listen and learn from a wide variety of stakeholders and data privacy experts. I am hopeful that the panel discussions will assist in identifying the role my mandate and the Commission can play in addressing the challenges related to raising awareness and encouraging recognition of the right to privacy in Africa, in addition to the related importance of encryption. Ladies and gentlemen, in closing, I would like to wish you all very fruitful deliberations in this important panel. Thank you very much for your attention.
Thank you very much, Commissioner King, for that wonderful speech. Opening remark, which I believe is quite very helpful in setting the pace for the conversation we are going to have today. I hope, I mean, from your speech, I could gather that you are going to remain in the session. I was really looking forward to that. You have said that you want to learn from the session, but trust me, we still want to be able to ask you a few other questions. So I'm really glad that you have opted to stay back and wait and see the session through. We'll be coming back to you to ask specific questions, especially within your role, within the context of the African Commission. Thank you so much. Let me use this opportunity to go to introduce our panelists who are already on the call and who will be joining the conversation. And as I already said, I'll still be coming back to the commissioner. So please, we know you said you want to learn, you want to hear from us, but we also still want to have, ask you one or two questions before the end of the session. So I'll just go to the panelists who will be driving this conversation. First, for them to introduce themselves, and second, for them to give a brief opening remark as we dive into the session. So I will go I will use my screen as the basis. I think the first person I can see is Ololade Shailon from Facebook. I don't know if that's enough as an introduction, but then I'll give you an opportunity to introduce yourself for those who don't know you, so that they can get to know you. You have the floor, Ololade.
Thank you so much, Boye. Good. So for me, it's afternoon, but I think for most others, it might be morning. So good afternoon, good morning to everyone. The Honorable Commissioner, Special Rapporteur on Freedom of Expression and Access to Information, my co-panelists, and of course, our other participants. My name is Ololade Shilon, and as Boye said, I work for Facebook and I lead privacy policy across Africa and the Middle East. It's a pleasure to be here today.
Thank you, Ololade. So let me go to Maxwell. Maxwell is the next name I see on my screen. Can you briefly introduce yourself?
Good morning, Commissioner. Good morning from Abuja, and good afternoon to those of you in Eastern Africa, and good evening to other parts of the globe, because I'm sure there are participants attending this from all parts of the globe. My name is Kadiri Maxwell. I'm honored to be part of this distinguished panel, and Commissioner, it's gratifying to be with you again twice in a week. That's not a common feat, so I'm grateful to be here. I work for the Open Society Justice Initiative out of Abuja, Nigeria, and this is an issue, or these are some of the issues that we are keenly interested in the context of the digital age. So thank you for the opportunity. I look forward, like Commissioner said, look forward to learning a lot from not just the panelists, but also the participants, because I see quite a number of experts in the room, from Madam Shailon, Madam Aditog, to Paul, Eva, and several others too. And of course, our moderator, Boye. Thanks a lot.
Yeah, thanks, Mr. Kadiri. So let me go straight to the next person on the screen, who will be our host, Paul. Can you introduce yourself for those who don't know you? Yeah.
Thank you, Boy. Good morning, good afternoon, and good evening. My name is Paul Chimome. I work with the CPESA as the Senior Program Officer for Research and Advocacy. I'm happy to be here. And for this session, Boy is our host.
Okay, I hear you. Well, so we have one more panelist who will be joining us later during the conversation. When he joins us, I would ask him to introduce himself, but we are going to just go straight into the conversation. And yeah, Paul, you were the last person to speak, and I think you also be the first person to, to give us an opening remark. And this is very important because a key element of this session is to kind of disseminate a research which CPESA had conducted, around this issue. So I would love for you, as part of your opening remarks, to quickly speak to that research. And then later I'll be coming to you to ask you specific questions regarding your work and how the issue of encryption probably relates to the work that you do. Thank you, Paul.
Thank you, Boy, and thanks to the panelists. So a few months ago, CPESA conducted a research, which was essentially an analysis of the laws and policies that have an effect on privacy. These specifically were looking at how surveillance has been regulated, provisions on data localization, biometric databases, and encryption and limitation of encryption. This research covered 19 countries: Cameroon, Chad, Egypt, Ethiopia, Kenya, Ghana, Malawi, Mali, Mozambique, Namibia, Nigeria, Rwanda, Senegal, Tanzania, Tunisia, Uganda, Zambia, Zimbabwe, and South Africa. I want to go into the mechanics of the methods, but in summary, our findings, because of the issues we're looking at, we note that there is a growing component on surveillance overall, and many countries have enacted several policies that permit interception of communication and surveillance by state agencies. And also these laws, the biggest problem that they had is that they provide a lot of powers. Some of the provisions are quite ambiguous. And one of the main reasons that the laws were passed and provisions included the need to protect national security, fighting cyber crimes. And while there are some positives in these laws, which criminalize illegal surveillance, many of the safeguards are really not so watertight as compared to those provided by the international human rights standards. So we see that for very many countries, the interception of communication and conducting surveillance is something they have taken up with a lot of eagerness. And many of the provisions are really copy and paste from the different countries. So you read a law from Uganda, Rwanda, Tanzania. What changes is just the name and the jurisdiction, but essentially the provisions are the same. Coming to the limitation of encryption, as the Commission has alluded to in her opening remarks, when you limit anonymity, you are really impacting on people's rights for privacy and privacy of communication, because we know that encryption in digital communications are very critical in advancing both the right freedom of expression and right privacy. And in the absence of these rights, the capacity of individuals to communicate anonymously and without fear of their communication being intercepted cannot guarantee it. We note that there are a few positive provisions in some countries that require the protection of data protection through technical security measures, which include encryption. But on the other hand, in many countries, we note that they have passed legislation that limit anonymity and the use of encryption through criminalization of possession and use of the cryptographic software and hardware. And they provide actually for fines and for prison sentence should you be found culpable. We know that in countries like Chad, Malawi, Senegal, Tanzania, Tunisia, and Zambia, there are penalties for offering cryptographic services without licensing or authorization. So, and then interception of communication provisions are also required that providers should be able to decrypt and encrypted information that they may intercept in the course of offering their services. And in countries as Malawi and Tanzania, the law requires the service providers upon registration with authorities, to disclose any of the technologies that they can plan to use for encryption. The other component that we're looking at is data localizations. Now, our findings show that there are a growing number of African countries that have been legislating on data localization, which has really mostly taken a form of a requirement to store data locally and forbid unauthorized cross-border data transfers. We note that various countries have specified the conditions for authorizing the transfer, mostly where the data subject has offered consent and where there is an adequate level of protection and assurance in the recipient countries or international organizations. Several African countries have adopted different approaches towards data localization, and they use laws on financial services. This is noted in Nigeria, Ethiopia, and Rwanda for cybersecurity crimes. This is also noted in Rwanda, Zambia, and Zimbabwe, and then for telecommunications in countries like Cameroon and Nigeria. Then also there are concerns for data protection, why data should not be transferred outside of the border. These are provisions we found in the legislation in Kenya, South Africa, Tunisia, and Uganda. And then they place restrictions on cross-border transfer of data. Some countries have actually specified data that cannot be exported without authorization. Then for others, they lump it together as data. Now, the danger with having a lot of data localized is that governments have a lot of access to it, and then they abuse, especially the process of collecting this data, the processing, and then the dissemination. So while we have laws on data protection, the provisions on data localization are quite ambiguous, and then some of them do not provide enough safety and protection. And the other aspect that we note in our research is that of all the laws that we've been able to analyze, there have also countries have come up with the establishment of biometric databases. So in several countries, government agencies are collecting and processing data, but without adequate data protection laws. And then even the oversight mechanisms are also very inadequate. And while many have recently passed data laws, and I think on the continent, more than 30 countries now have a data protection law, the implementation is really not effective. And in some cases, the safeguards are not watertight as required by international law. So some of the principles, like for the rights of data subjects, consent is really not put into consideration. So we see that in countries such as Chad, Tanzania, Zimbabwe, Uganda, South Africa, they prohibit the collection of certain categories of data, including specific data on biometric generally, or where certain conditions are not complied with. But in other countries, the laws require the mandatory collection of biometric information for the registration of subscribers, digital identity programs, voter registration. And also it is that several of the laws and policies on data collection, they contain provisions and sanctions for breach. So we know that there are a number of programs like the mandatory SIM card registration that I think has been adopted by most of the countries in Africa. So it is these laws on collection of data that have enabled, and in some situations, the programs were started on even before there was clear provisions or safeguards in law to ensure that the data collected is actually processed within the limits of the law. And then lastly, we note that there are weak oversight provisions within these laws. They don't provide for accountability and transparency mechanisms. And note that different countries have adopted approaches to oversight, including specifying courts, data protection authorities, sector regulators, and administrative bodies as oversight bodies. Unfortunately, some of these are in countries such as Kenya and Uganda. While they have appointed the data protection officers, these offices have really not become functional because, one, you find that they're just one individual, the head, who has been appointed. There is no budget allocation to that office. And when you don't have finances, it has a lot of limitation on the kind of the work that you do. While some laws require countries to review judicial authorities to issue warrants for interception of communication and monitoring, we note that for many cases where interception has been conducted, this provision has been sidestepped. And so the deficiency of accountability and transparency is one of the weakest links in the various countries on surveillance laws. in that while such countries as Nigeria, Rwanda, Tunisia, Zimbabwe have commendable oversight and accountability provisions, it is not known whether these are actually applied. So for most of the laws, they end on paper, but when it comes to application, there is a lot that is lacking. I would want to stop there for now. We have some recommendations, but I think these are things we can discuss in the next submission. Thank you.
Paul, for stopping at that point, and for not waiting for me to say you should stop. So I'm just going to, move straight to Ololade at this point. Paul has, raised a lot of issues, speaking to the that one of the key things that came up very strongly, in the summary of the overview that Paul just gave, was the issue of local data localization. Without appropriate safeguard or system in place. Work for a global tech company whose influence and impact spreads across jurisdiction, both in Africa, outside of Africa, and with different framework in place around surveillance, around things like encryption, and particularly around the subject of data localization. I would love you to speak specifically on data localization because of the significance of that to the kind of work you do, and given that your organization is a global organization and deal with data from different jurisdictions and all of that. What are the implications of the current, or some of the recent policies that we have seen in this part of the world? I want to speak specifically to the African context, and what are the challenges that you have seen? What are the trends that you have seen? And how do you think this can affect not just your organization, but the tech, the general tech or innovative, system in Africa, and the capacity of Africa to create or build on the digital economy that can also maybe improve our laws as Africans? Ololade, you have the floor.
Thank you very much, Boye. That is actually an exam that you've given me, but I'm going to try and speak to that, very briefly, and give space to other panelists. So first, I want to mention that as a business, we take human rights very seriously. As some of you will know, our mission is to give people power to build community and bring the world closer together. And embedded in this mission statement is really a recognition of the importance of freedom of expression and voice as critical in helping people to build community. And we also recognize that for many people, to freely express themselves, they must, be sure to feel safe, and a major part of ensuring that security is ensuring that communication is actually private. And we know that the difference that private messaging makes in helping people to actually on the continent to realize their rights, whether it's freedom of expression or freedom of association, to be able to mobilize. And so, by extension, protecting the privacy of our users as it entails private messaging is extremely, extremely important to us. But at the same time, as a company, and you alluded to this about, having different jurisdictions and different rules across the world. We also want to be very responsible corporate citizens, as with other digital service providers you will find around the world. And so we strive to comply with local laws. Of course, the question then is what happens when we are required by local law to then contribute to unlawful surveillance by, for example, providing access to the data of our users. And that could be, whether in terms of backdoors to encryption or actually the requirement to localize data and then subsequently to then share that data with the authorities. It's really a tough position to be because many times, as you can imagine, failure to do what is requested or what is required might lead to the fact that the platforms that we have will not be available to citizens in that country for extended periods of time. In any case, we, in March, launched our human rights policy. And that's the standard we want to be held to account for in terms of how we approach all the issues that we do or all the services that we provide as a platform. And the commitment that we made is to recognize the diversity of laws in different locations that we operate and where people use our products, and to strive to actually respect domestic laws. However, when faced with conflicts between such laws and other human rights commitments, we seek to honor the principles of internationally recognized human rights to the greatest extent possible. So that is what our commitment is. In terms of what we're seeing in the region on localization, Paul already spoke to that. We're seeing requirements for hard localization, right? Where you need to store data locally, have servers locally, and process that data there. And so you will see that, for example, in very recent laws, like the Rwanda's data protection law, the Zambian one as well, and Kenya also has a bit of a flexible provision requiring that the minister actually sets the tone of how that's going to work. And we are expecting to see that in the regulations that are being finalized as we speak. So hard localization is probably the most problematic bit, but we also have soft localization where you're not told to store data locally, but then it's basically being made impossible to not store the data locally. And so you're in a roundabout way being required or given such tough and high conditions to be able to transfer data outside of the country. And let me also say that I mean, you will not see, I haven't seen any data protection that doesn't have some kind of restriction on transfer of data, which is perfectly legitimate. It is how reasonable those restrictions are and how it's actually, how far it goes in preventing, free flow of data is what the issue is. So whether it's hard or it's soft, that's the real issue. And also to flag that the other issue that was raised by Paul is that we see a lot of sectoral laws as well. So you might not have like an omnibus, like a general law, but you might find like in the banking sector, for example, the requirement to localize, or in the health sector, for example, the requirement to localize. So those are all the kind of things that we're seeing in the region. And just to flag two of the reasons, also alluded to by Paul, of why that we come across as justification for this when we engage is that of national security, So the perception is that if the data is actually stored locally, then it makes it easier for government to be able to protect the national security of whatever country it is. But you also know that that is not necessarily how things pan out, right? Because we know, at least for one in our continent, that national security is often used as a trump card. And so how do we then know for certain, or how do we then guard against it being used for exactly that, as a trump card? So that's one thing. The other reason that we see is also, ironically, to protect the privacy of users. But as you can imagine, think about storing data in only one data center locally where everybody knows this is where the data is. Doesn't that make that data then more susceptible to, it being attacked by malicious actors and by bad actors? So it actually makes more sense to have like distributed systems to be able to then, secure the resilience of, of the internet as a whole, but also of, data, so to speak. So yeah, those are some of the issues that I wanted to flag and to say that, it's often a tough balancing act in terms of, the way these things happen. And generally speaking, we believe that, it's very important that, and this probably will come to this when we're talking later on about what kind of mechanisms or what kind of things we want to suggest of how things should proceed, is that I wanted to just flag that. So we made a commitment in March 2019, that we will not store data locally in places where we believe they don't respect human rights, in particular, privacy and freedom of expression. The question that I'm sure comes to mind immediately is then to say, who then determines, or makes an assessment of whether a country in Africa, for example, respects, freedom of expression or privacy? Who does that? And I think that's where I think the Commission can come in, as the body in charge of human rights protection, as the foremost body in charge of human rights protection, to actually help us expand, on the work that has already started with the declaration. Expand on exactly how do we, first and foremost, judge a country to be compliant with their requirements in terms of, communications, surveillance, and the standards that have already been laid down by the Commission. But we need actually more clarification. because we believe that that's going to actually help not just companies like us, but also even CSOs and others on the ground to be able to actively advocate and be able to have more clarity about, what constitutes infringement on the rights of citizens, especially in terms of compliance with the obligations of member states of the African Charter on Human and People's Rights. Thank you very much, Baye.
Yeah, thanks, Ololade, for that intervention. It's quite helpful. And I think you've raised a lot of fundamental issues, and which I don't know if the commissioner is still on the call, because she might have to leave at some point. So I really would love to have her respond to, particularly you've challenged the commission on a possible role that the commission could play with respect to, for example, creating standards in helping global tech company and other people who rely on data for business determine which country, for example, has the right laws or has the right system in place towards the protection of the right to freedom of expression and the right to privacy. I know the commissioner, when you were giving your open remark the other time, you had spoken to the declaration and which you have kind of advised us to look on and leverage. But I just would love for you to quickly intervene before I go to Maxwell at this point, especially with regards to the challenge which I think Lade has directly put in front of you regarding the role that the commission could possibly play with regards to creating standards that can help global organizations, not just global, even local organizations, something that they can hold on to say that okay, on the basis of maybe the leadership or the guidelines that the commission has provided, we are making so and so decision. Commissioner King, how do you think we can, as stakeholders, how do you think we can leverage the work of the commission to arrive at that point?
Thank you very much. I was just going to send a note that I have to leave now, but I see Eva is still with us, and Eva has put some information on the chat box referring to the principles in the declaration. So I think I would kindly ask Eva, because I was partly not here when you were asking the question, if she can respond to that question. I'm sorry, I'm afraid I have to leave now. I've just been called. I have a court hearing. So Eva, over to you. I'm sorry to put you on the spot, but I know you're always ready. Eva, please take over. Eva is the senior legal officer at the African Commission on Human and People's Rights, and she's been working on the mandate of the Special Rapporteur for years and years. I know Lade and others, they are they can attest to that fact. So Eva, over to you.
Thank you, Commissioner. I hope you can hear me. My network is not so good. I had just sent some communication to Commissioner King. I had sent her the provisions of the revised declaration, specifically Principle 41.3. I'll put it up for everyone to see. I'm not sure it addresses the question, but I'll just send it to Commissioner King. I'll just reference it. It says that states shall ensure that any law authorizing targeted communication surveillance provides adequate standards for the right to privacy including, and then there's some provisions indicated. So I was sending this to Commissioner King just to highlight that in terms of communication surveillance, there are some standards which are in the declaration, which the state has to adhere to. And the role that the commission can play is that to just buttress these standards, and the role that the CSO, the stakeholders, can play is to keep referring to the declaration to tell the state that these are the standards that they have to meet, and to encourage the states to meet these standards in addition to reporting to the commission on their fulfillment of these standards. So that is just the basic thing that I had raised with Commissioner King. Thank you.
All right, thank you. I mean, I see a lot of positives from the response, and I hope that we can leverage on that. But I will come back to that conversation again towards the end of the session, because right now I want to bring in Mr. Kadiri from the Open Society justice. And a number of issues that I want him to speak to, because, I mean, he is more from the civil society world, and probably civil society feels the implication of some of these issues that we have talked about mostly. For example, I think civil society are one of the greatest beneficiary of having encryption, for example, operationalized in different countries, ability for people to be anonymous online. And also, when we talk about data localization, is jurisdiction where there is no history of respect for human rights and all of that. Civil society organization, human rights defender are likely to be more on the receiving end. So that's why I want Maxwell to speak on the implication, on the limitation of encryption, the implication of data localization. A lot of countries are insisting, for example, that data has to be localized. What is the implication for civil society, for human rights defenders, especially when you look at it vis-a-vis the tendency for government to surveil citizens, of course, in the guise of national security? What does that mean for the ability of people probably to engage government, whether criticize the policies of government, or even just do their right as civil society organization, as their right, they are working with respect to holding government accountable? Maxwell, can you kindly educate us? And how can we push back on the adoption of surveillance laws, surveillance tools, and also insistence by national government for data to be localized? Thank you.
Well, thank you so much, Boye. Well, I would start by saying I would want to thank CIPESA, and all the researchers who worked on this particular study, that we're discussing now, because I believe it would not have come at a more opportune time. Incidentally, on Tuesday, we had the International Right to Know Day. I'm just using an acronym for that. That's not the full globally accepted expression, but I think it's Universal Day on Access to Information. And the commission, this Commissioner King, alongside Madam Eva, convened a webinar, on Article 9 of the Declaration, or Article 9 of the African Charter, but with particular emphasis on the Declaration of Principles on Freedom of Expression and Access to Information, which was also the framework that was utilized in developing this research. And it was quite an instructive conversation that also had participation of member states to the African Charter on Human and People's Rights. And I see a connection, between what happened on Tuesday and what is happening here, because again, I spoke on part 4 of the declaration, which is the substance of our conversation here. And one of the things that came up from that conversation, or one of the recommendations, I'm not trying to jump the gun, but just following up on the conversation the way it's flowed, is for the fact that going forward, in terms of the state reporting mechanism that currently exists under the African Charter, that going forward it will be instructive for the special mandate on FOI and ATI, to insist that when state parties present their state party reports, that the state party reports follow, respond to all the issues in the declaration, and not just having generic, what used to be the case of having generic reports on maybe 2 or 3 paragraphs on this is what we have done on Article 9 of the declaration. But because after Article 9 of the Charter, because what the declaration does is unpack in practice, what Article 9 of the African Charter means. But when we even go further, in the context of the declaration, particularly part 4, you will then see, like Madam Shillon had also referenced, the need to further unpack the declaration in terms of its implication in practice. And that's why going forward, just by way of just one quick suggestion, would be that now that we have this research, which gives us in broad strokes a lay of the land of what exists in the different countries, it would then be useful for stakeholders in the respective countries, particularly civil society groups, to build cohorts, that then further deepen the conversation and then avail the commission with further information premised on what we already now have in this research that then guides the commission's engagement, with member states, not just at the level of state reporting, but even at the level of promotional missions that the mandates also undertake, and that this then provides a base material going forward for engaging with the issues across board, in terms of all the state parties to the African Charter. I do believe that there's enough information in this research that will come in handy in that engagement going forward. And so we don't have to go into those conversations blind, but with the benefit of the information that is currently available to us. So that would be my quick response on that score. But back to the question you asked, Boye. Of course, it's the case that civil society is at the receiving end, of a lot of the issues that have also been flagged thus far. And it's quite challenging because you also find that given the fact that the way politics has evolved, in many of our countries, and it's also sad that in some of our countries, particularly in the context of West Africa, we're also having a regression of democracy, and now also having militarization of governments and having coups and counter coups and a lot like we've seen more recently in Guinea. But even in countries where we still have the practice of democracy, what you find is the dominance of the ruling party, and then the weakening of the opposition party. And by necessary extension, and because in many of our countries, you also don't have principled politics. And I mean, by some of our contacts in the political parties in my host country where I'm speaking from will tell you that 4 years is a long time to be in the opposition, in terms of just being able to leverage access to resources. So what you have is once the expression, there are no permanent friends or permanent foes, but permanent interest in politics. So once one party wins at the polls, give it 1 year at most, 2 maybe, you would find the opposition party emptying into the ruling party, for purposes of wanting to be able to access spoils of public resources, for their benefit. And what that does is it then creates a vacuum. And they say nature abhors vacuum. So what you then have is civil society having to step in, in addition to playing the role of holding the government accountable and enabling the voice of the citizenry to be heard within the purview of public governance. Now also kind of playing the role of that the opposition parties would also have played. So you then find that as a necessary corollary of that, the government gets very uncomfortable with civil society and would go after civil society in terms of basically with a sledgehammer, because they see them as an inconvenience, that should not be allowed to continue to exist. And that's the experience from, I wouldn't want to mention names in terms of countries, but whether you're talking of East, whether you're talking of Southern, whether you're talking of West Africa. And so a necessary implication of that is a lot of the challenges that this research flags now negatively impacts on the work and the operations of civil society. And so and even in context, I would even want to take it further, because Paul also referenced that in some of the countries you have laws that also have some level of positive safeguards. But I'll give you a personal experience. We've had engagements with law enforcement agencies in some countries, and they basically just tell you that by the hotel where you are living, there's a vehicle parked, and that vehicle is a bus. Outside is like a regular bus, but that vehicle has all the gadgets, that enables access to whatever communication device that you have. And in some instances, when they say it to you and say to you gleefully, it makes you have sends blood chills down your spine, because you then know that what you thought was protected communication that you were having with your colleagues, even your colleagues sitting next door to you, is visible to these institutions, and they can use it to come after you where the need arises or where they feel that there's a requirement for that. And as has also been clearly identified, a lot of this is done under the guise of national security. Again, issues around fighting terrorism, counterinsurgency, and in the host country where I live now, there's also the talk of banditry, you know, and also extend it so much further. I mean, again, maybe not clear, not closely integrated with the subject of this conversation, but also broadly connected, is the current practice we're experiencing here, where communication services are shut. I mean, totally shut, you know, under the guise of also dealing with issues of insurgency, banditry, and under the guise of national security. And when it was piloted in one of the locations, you know, some of us raised a red flag that this is a crazy development, you know, that is going to be copycatted and also expanded beyond that location. And that's what we're beginning to see. So what am I essentially getting at? That it goes without saying that these, whether it's weakening of encryption, whether it's data localization, whether it's surveillance, all of these negatively impact on the ability of civil society to play their role as the watchdog in society, holding the government to account and also enabling citizens get their voices heard, you know, within the wider frameworks of public governance. And I would also want to just wrap up with this. Incidentally, some of us were involved in some of this conversation much earlier, many years ago, without also fully appreciating the implications. Because Lola and Boye, you would also readily recall, there was a time in the context of the tech and digital rights sector where there was advocacy for setting up internet exchange points in countries. And the argument for that was the need to keep local traffic local, you know, because it also enhances efficiency, reduces the need for bandwidth, and then also enables speed in terms of access. But at that time, we didn't also quite appreciate the implications in the context of data localization, as well as in the context of surveillance, you know. So, and that's where we are now seeing all of that play out. So how do you then strike the balance? But as with many of these issues, even where there are positives, more often than not, the government use the arguments of the positives to get into the building, but the ultimate objective is to max out on the negatives from the perspective of holding on to power. And like we know in many of our countries, once in power, people never really want to leave power. And what is defined as national security in many of our country contexts is actually not national security, because national security takes into consideration the needs of the ordinary man on the street. What is defined as national security in many of our country contexts, it's actually regime security. So as in this conversation, let's redefine that expression, you know, to actually look at it from the prism of regime security. Because if you are looking at national security with the citizen at the center of the need for national security, then it will not be difficult for us to stick to the standards, you know, that are suggested both in the international human rights instruments and that are also being proposed in the context of the Declaration of Principles of Freedom of Expression and Access to Information. So I'll rest my case there. Thanks.
I mean, thank you so much, Maxwell, for that intervention. I mean, you touched on a lot of things that that resonates with me, or that I can really relate with. And we can begin to even unpack them one after the other. It seems as if these issues have been with us for so long, even though they might be in different contexts, but they seem to have always been around within different contexts. Let me just use this opportunity to tell all our participants that it's a good time for you to, drop a comment in the chat box, or if you have a question, please use the Q&A tool on your Zoom to drop your question so that we can begin to answer those questions, so that we don't have to rush the question, and answer sessions towards the end of the session. I think we still have roughly about 30 minutes to the end of this session. So please, let's feel free to start to ask our question. But let me quickly say that Kuda has joined us on the call, and I would love to quickly go to him so that he can, introduce himself and then answer this question. So Kuda, my question to you would be for you to help us in this conversation. Your organization, Privacy International, does a lot of work, promoting the objective of privacy, and you've focused not just on government, you have also focused even on businesses, on tech companies, and all of that, trying to hold them to account, trying to also, bring a lot of attention to what are the best standards when you talk about privacy, and also vis-a-vis the subject of surveillance. But I would also want you to speak a lot on the issue of encryption. You are aware, and I'm sure that you must have looked at the report, that a lot of governments, especially in Africa, and I don't think this is just Africa, I think this is also true of many governments, even in the global south. A lot of governments are beginning to, to really clamp down on encryption, trying as much as possible to lessen the ability of citizens to use encryption tools, ability of civil society organizations to leverage on encryption in their work and all of that. So from your perspective and within the context of the work that you do, what are the trends that you have seen and what are the best standards? And I would love for you to speak more on the best standards in how we can push or argue for the need for encryption to remain a right, to remain available to citizens. What are the best advocacy approach and what are the best standards that you have seen or that you have proposed as an organization in this context? Kuda, you have the floor. Please not forget to introduce yourself, because many people on the call don't probably know you.
All right. Thank you very much, and my sincere apologies for joining this a bit late. Thank you again to the organizers of the panel for inviting me. So I am Kuda. I am with Privacy International. I am a policy officer there. So I mainly do policy research and policy analysis. I am not the one leading the organization's work on encryption. The person that leads the work could not be here today, but I will do my best to stand in their shoes. So what we have noticed, rightfully, as Maxwell was saying, is that whenever there's a challenge to the use of secure communications and secure communication platforms, the first justification for that is not going to come as we want to listen in on what people are saying. The justification will always come in through either a noble cause, such as we want to fight terrorism, we want to fight illegal migration patterns, we want to fight other negative issues, especially in African countries that they talk a lot about cybercrime and the protection of the cyberspace and even national security. Maxwell covered that very well, so thanks to him. But what we are seeing is that sometimes, and this is a very recent example, companies, for whatever reason, take the initiative themselves. So a very recent example of this was the proposal by Apple as recently as 2 months ago, or a month ago, where they were saying that they want to be able to scan photos of people's photos in people's media libraries to find out child sexual material. On the surface, that's noble, but it is an example, just one example of a company taking it upon themselves to solve an issue that has other possible solutions that are less intrusive. So for some reason, there's a belief that listening in on what people say through communications is the best way to fight crime, even if, for example, there are other solutions. So for example, with the Apple situation, it's very clear that with child sexual abuse issues and child sexual images sharing, the perpetrator, studies and research have found that the perpetrator is usually someone that is closer to the family unit. So solutions would logically be expected to aim at that level. Like, let's start seeing what we can do to protect the child within the family, within the neighborhood, and within the community. But companies then overlook that, overjump that, and then they go and see other solutions which are a bit excessive and over the top. Why do companies do this? It could be an issue of accessing more information, because when backdoors are created into communication channels. So, for example, we see a number of countries in Africa passing either interception of communication laws or cybercrime laws or other forms of telecommunication laws that make it a responsibility of the telecommunications company to have equipment, whether it's hardware or software, which allows for real-time recording or listening into conversations or interception of messages. So when that happens, say a company, my service provider in my home country of Zimbabwe is listening into my conversations, they will not only listen into conversations where maybe I am talking ill of the government or criticizing the government, but they'll also listen in on my conversations when I am maybe buying something, when I'm discussing health choices or discussing providers for certain services. So the creation of backdoors into communications creates an opportunity for the people with access through that backdoor to cast a very wide net on the information that I share. And that wide net may include also information that may be monetized and may be profitable to them. So besides the criminal investigations, besides making sure that I'm not a terrorist, they might also get insights into how I shop, how I have fun, and from there they get marketing opportunities, which they then can turn into monetary possibility or profit for them. As for advocacy opportunities, I think it's very important to get members of the public involved, because what usually happens is that it's organizations and workers in those organizations and researchers working with those organizations that usually come together and we geek out, we go all out on, did you see how this company is threatening encryption, or did you see how this company is doing that, or this government law? And in those conversations, it's so easy for us to lose our ability to involve ordinary people. Remember that in most African countries, members of parliament are voted into power by popular vote, and it is those members of parliament that are then responsible for deliberating the laws that we are now in this panel talking about. So we need to intentionally involve members of the public in those conversations. So advocacy tips that might work. Let's simplify the language that we use around encryption, because a lot of people don't understand what encryption is all about. So, for example, there's a misconception around the use of technologies such as VPN, virtual privacy network technologies. There's a misconception around encryption. So when we talk about, for example, Facebook products that are encrypted, which is, and I refer to Facebook because it's mainly what we use on the continent. So things like WhatsApp, things like Messenger, we forget to mention that the encryption happens when the messages are in transit. But ordinarily, when the message has been delivered and decrypted and sitting on my device or the device of the person I sent the message to, then it's not encrypted. But when you then have discussions with people, you start picking up these misconceptions. They think that it's safe, so they will send anything and everything, forgetting that at the end of the day, the receiver of the message can pick up that message and go with it to the police station. So the encryption in that instance or in that scenario does not help or does not have the effect that they thought it would have. So when we involve people, then those people can actually approach their members of parliament, they can approach their lawmakers and policymakers and challenge them to actually stop introducing laws which create backdoors. And lastly, the one thing that maybe we need to point out is that once a backdoor is created, once there's an opportunity for someone or some organization, whether it's a state security organization or a commercial entity, has the opportunity to listen in on communications, then it's no longer safe for everyone, because it's only a matter of time before a third party with ill intentions exploits that backdoor. So, for example, we've been reading a lot over the past few months about the NSO group, which is taking advantage of exploits in the iOS or Apple ecosystem. So, if there is one backdoor, then it's not just going to be used by that one entity that pushed for the creation of that backdoor, but it might be exploited by any other actor who's got maybe ill intentions or ill intent, and that may actually lead to greater harm. So yeah, that's my hopefully brief contribution. Thank you.
Well, brief, not so brief. Thank you very much for that contribution, Kuda. I'm sure it's helpful, and it's more importantly, it also helps to put this conversation in perspective, because one thing we want to really dwell on is on this issue of encryption because of its relevance and significance for a lot of organizations working on digital rights issues. There has been a constant pushback on the part of government across the globe, trying to say we need to do this because of national security, and almost all the speakers have also spoken to that in terms of the use of national security as an excuse. And it was also great that you mentioned the recent case with Apple, whereby it says it wants to address online pornography, child pornography by installing the ability to literally see the gallery on everybody's phone. I think it was good that you brought that into the conversation, but I also think that for many of us on this call, and for those who are working on digital rights issue in Africa, one of the risks or one of the anxiety that we have is that as government continues to expand its capacity for surveillance, people who do civil society work, people who advocate for digital rights are, continuously in danger in terms of their ability to do this work, in terms of their, ability to stay anonymous, for example, to expose corruption, to call out government ineptitude, etc. At this point, I've checked the Q&A and I can't see any question yet. So let me use the opportunity again to tell the participant that this is a great time for you to drop your comment in the chat box. If you have a question, please feel free to put that question in the Q&A section so that our panelists can pick on your questions. We have just about 20 minutes to do all of that right now. But while I'm expecting your question, I want to quickly go to Hilda. Hilda, I don't know if you're still on the call. I'm really looking for you. Okay, I think you are still on the call. And I just want you to, if you can help us with respect to the work of the African Commission. I think that one of the things or one of the challenges that people see with the role of the Commission or even the African human rights system, it's generally to the extent to which state parties are willing, for example, to implement the decision of the courts or even sometimes the resolution of the Commission. From your perspective, I just want you to kind of educate us in terms of what do you think are the things or are the missing link, especially for civil society organizations who are looking for regional human rights system to, my apologies, it is ever not Hilda. Please pardon me for me wrongly for the wrong way in which I called your name, Eva. So if you could please help us within that regard, what do you think that civil society organizations are not doing right within the context of digital right, the context of privacy right, but generally within the context of leveraging the work of the African human rights system? What do you think civil society can do better? How can they leverage the system better to, because sometimes it's difficult to get national court, for example, to intervene. I mean, there are a lot of issues around, clamped down by government and all of that, that the local courts are proving not very effective, and people are looking really forward to the African human rights system. What do you think, from your experience, what do you think civil society organizations are not doing right? Where would you love to see them do better to leverage the African human rights system to push back on some of these effort by African governments to restrict the right to privacy, to clamp down on encryption, and in other work that civil society organizations do? Eva, if you can unmute at this point, please kindly intervene within the next 3 minutes.
All right, thank you. I hope you can hear me.
Yes.
I actually didn't know that you were addressing me since you had said a strange name, but afterwards you said my name, so I realized it was addressed to me. I think I wouldn't say that's what the NGOs are doing wrong, or civil society. I would say maybe what we would like to encourage them more to do is to bring situations of violations to the Commission's attention, the Special Rapporteur's attention. So, for example, when there was a recent Twitter ban in Nigeria, many organizations came to the Commission and said, no, you have to say something. So the Commission issued a press release calling on Nigeria to address this issue. And the benefit of this is that now this press release is going to be referenced in the Commission's activity report, which goes to the policy organs, and it will be presented before all state parties. And perhaps then at this point, the state party will take the floor and now try to defend the action it's taken. So I think we would like to encourage CSOs very much to keep coming to the Commission with allegations of violations. And since digital rights is an emerging issue, I would say, I'd also encourage CSOs to bring such reports to the Special Rapporteur's attention. So for example, this report of CPESA, I believe it's called, bring it to the Commission's attention, send to the Commission, propose action that the Special Rapporteur can take. Do you want her to do, like, for example, an interaction during the session on right to privacy, for example? Raise this with her, engage with the Special Rapporteur as much as possible to get the Commission involved in the work that you do. I would say that this is an important thing that the CSOs can do. Another thing is in the submission of shadow reports to the Commission. So for example, now we have a number of state parties which have periodic reports to be examined by the Commission in a future session. So there's Kenya, there's Namibia, there is Benin, Eswatini, and another state. They're on the Commission's website. So I would encourage CSOs to submit shadow reports to the Commission and raise these issues. Raise issues of encryption, raise issues of surveillance under Article 9. Show the link between, for example, any surveillance and how it may actually not be justifiable under national security. So now the Commission can engage with the state in public session and ask them, what is happening in this thing, and your responsibility, which is now stated in the Declaration of Principles, can actually be shown. So I would just encourage CSOs to engage much more with the Commission, to bring these issues to the Commission and to the Special Rapporteur, so we can do as much as possible. We can raise awareness on them. The last thing I'd like to say is on the Commission's protection mandate. You did mention, unfortunately, that maybe national courts have not dealt with these issues very much. But to the extent that they have, you can raise these human rights violations in the form of individual communications under Article 55 of the African Charter. Unfortunately, you'd also have to have exhausted local remedies. But if you can make a case that the state has, the courts have delayed in granting a right, then perhaps it could be admissible, and then the Commission could now deliberate on the case to see whether it's a violation of the African Charter. So I just encourage CSOs, actually maybe is the thing to do actually is to engage more with the Commission, to engage more with the Special Rapporteur, and also to reference the revised declaration as much as possible in their local work, so there can be more awareness of the declaration and of the African Charter and the Commission. That's what I would say. Thank you.
Thank you very much for that intervention. And I believe that most people on the call are able to pick one or two things. I think it's very helpful in terms of bringing issues to the attention of the commission. Let me check whether we have questions on the chat box yet. Okay, I don't think we have any question yet. So I'm going to go back to Ololade at this point. You've listened to the different contributions, especially with respect to the intervention before, the earlier intervention where we're talking about leveraging the African human rights system as maybe the acceptable standard. What do you envision as challenges with respect to relying on the African human rights system, for example, as the basis for decision making? Because I know sometimes national government puts a lot of pressure on businesses in terms of trying to make you play according to national rules, national laws, or national interest, as they like to put it. What are the challenges you see, especially with respect to the subject of encryption? And I want you to speak also bearing in mind the fact that Facebook has assured its user that, for example, WhatsApp is an encrypted communication platform. But then there are times when government says that we are investigating crimes. I know there are countries that have passed laws on lawful interception of communications, for example, and those laws, you have to probably obey those laws. Now, look at it vis-a-vis the standards that the African human rights has created, or just generally regional and international human rights instruments. To what extent do you think a global corporation like yours can, fall back on this regional or international human rights system to say, yeah, although you've asked us to do this, you've asked us to do this, but this does not align with what the global human rights, best practice is saying? To what extent are you able to do that? Can you just quickly speak to that in the next 2 or 3 minutes?
Thank you very much, Boye. 3 minutes is a very short time. Okay, so what are the challenges within the African human rights system that I can share with you? So, of course, as Eva already mentioned, generally speaking, to approach regional human rights mechanisms, you need to exhaust local remedies. That is usually seen as a stumbling block by a lot of CSOs. But as she referenced as well, there are circumstances in which you can, approach a human rights body and explain to them that, local remedies are either not available, or even if they are available, they are not able to do what they're supposed to do, and then that can be taken care of. So I think that's one hurdle that I think is can be taken care of. And I know for sure for the ECOWAS court, exhaustion of local remedies is actually not a requirement. And so you'll see that it's possible to approach the ECOWAS court, on issues around violations of human rights. The other thing I wanted to mention is that it's possible, even though I said it would be good to have like the African regional human rights system actually expand on the normative frameworks, because I think that ensures that we look at the peculiarities of the region and come up with standards that are actually best suited to address those peculiarities that we might not see internationally. And so to the extent that you can also rely on other global standards, even when you approach the commission, that's fantastic. But it's ideal to have very specific standards for the region on which one can approach and sort of try and get the commission to intervene when these rights are violated. One particular challenge I want to flag is the time it takes for, especially when it's like you're looking at the protective mandate of the commission, the time it takes to actually bring a case before the commission, because there's a 3-stage process. It has to be seized, which is generally or relatively straightforward. The commission has to be seized of the communication, and then there has to be a decision on admissibility, and then a decision on the merits of the case. That will take a long time. And so sometimes, as you say, justice delayed is sometimes justice denied. I think sometimes that could be a challenge. Of course, not for a company like us to approach, but for CSOs or other stakeholders on the ground to be able to approach the commission and to be able to get a decision, to to be made on these issues very quickly. Of course, that's on the protection side. But as if I feel like there's also other things that can be done, right? Like you can, approach the commission, raise the issue with a special mandate, and there can then be like an appeal, for example, directly to the relevant state to ask them what's happening and to ask for them to take urgent action. Of course, still with that, it's still very difficult to enforce, and that's why we have the African Court. But as you will know, with the African Court, you can approach the African Court directly. There are several, layers to it. So if the country, has actually, made the declaration to allow individual communication, then you can approach the African Court, which of course is a court, unlike the commission is a quasi-judicial body, and can then make, binding decisions, which will then have to be implemented. So those are some of the challenges I can mention, because if your country hasn't actually made that declaration, then that means that you can't approach the court. You have to stick with the commission and use whatever avenues are available to you within the African Commission's framework. So in summary, that's what I would say. There's a lot more I could say, but let me just stop there.
All right. Thank you very much. I'm also very conscious of the time. We have very limited time left, and I will also still want Paul to come in and also Maxwell to come in with regards to, I think Maxwell, what I would really love you to speak about right now is in terms of looking at everything that has been said and looking at the recommendation that we have in this report. There has been a lot of, in the recommendation, I see a lot of references to the need for privacy policies, a promotion and protection of the right to privacy and data protection, public interest litigation. But I just want you to speak to what would you say is the one thing, if you have on a platter of gold, like an open check, that this one thing, if you ask for it right now, it will be done. What would be that one thing you would want to see put in place within the context of ensuring that we do not lose the right to be anonymous or the right to encryption services? What is that one thing you would ask for? So this is an open check. That very one thing, that's what I want you to speak to.
That's tough, eh? But my one thing, because there's no silver bullet, but my one thing will be a redefinition of national security from regime security to security of the ordinary person on the street. Because if we did that, that enables effective implementation. In fact, that changes the entire narrative of the conversation we're having now. And we would move from a scenario where these violations are taking place, whether it's breaking encryption codes, where these things are utilized for the benefit of the political elites or those in power, to the detriment of the ordinary person on the street. That would be, for me, what changes the conversation.
Interesting. Once we define, national security, it is going to even change the trajectory. Oh, are you still talking? Sorry.
Yeah, no, what I'm saying is, and I'm talking holistically now, okay. That is, so it's not just redefinition, it's also changing the entire paradigm, of what national security means, because that is the rubric in which a lot of these infractions take place. And the interesting thing is, when you come to the acts, because this conversation straddles several rights. So when you come to the access to information perspective, what the governments use to deny access is national security. That's the biggest elephant in the room. When you come to the context of privacy, what the government uses to deny the right to privacy is our concerns of national security. So you find that, and when you also, so you find that across board, even in the context of free expression, that is also what they use in denying it. So you find that across board is a lose-lose situation once they introduce that dynamic into the conversation. And yet, engaging on what national security is and means is something that has not been done, at least for the benefit of the ordinary person on the street. So just changing that paradigm to say national security is not about regime security, it's not about the security of political elites, It's actually about the security of the person on the street, changing the conversation and brings everybody to the table for us to be able to reduce this. Thank you.
Yeah, thank you very much, Maxwell. I see that you are very passionate and you were going to just go on and on, but I look at the time and we have practically run out of time. And I also want Kuda to just say a final word. What does it feel like to be in a world without encryption? Kuda, just a statement. What does it feel like to be in the world without encryption?
It really would be a difficult time because encryption is one of the last grounds upon which we are protecting the right to privacy, free expression, and even the right to assembly and association. So it definitely helps to enable the enjoyment of those rights.
Thank you very much, Paul. Thank you very much, Kuda. So, Paul, I want to give you the right to end this session for us. The report is out there. The research has been done. What do you want us to do with that document? What should we do about it, and how do we take it forward?
Thanks a lot, Boy, and to the wonderful team of panelists for the contributions. The discussion has really been enriching. I think for us and many other partners working in the digital rights space, what we want to do is to build a board of knowledge that can be then the basis of doing interventions, including approaching the office of the special rapporteur, because I think Eva in her remarks was like, there are very many ways of us to approach, but then you can't approach some of these entities empty-handed. So you need to, we need to continue documenting. We need to use available illustrative examples, because if you are going to make a case, then you must show, because even the commissioner cannot just base on hearsay to hold governments accountable. She needs evidence. So we need to continuously research. So this report is just a contribution to analyze what is happening in the different regions. So we welcome additional contributions, but also for partners to use the findings therein to ensure that when they are developing the advocacy messages or strategies, they use this evidence to try to build onto it. Also for pushing their governments to respect, because we note that in this report, there are a number of countries that have passed privacy laws and even other laws. There are some good provisions. If they only respected and held accountable anybody who is abusing these provisions, I think it would be a much better starting point. But there are some good laws, they are not respected. And even the violations, people are not held to account. So if we can start with that, for the national governments to respect, then hold the abusers accountable, I think it will be a very good starting point for us. Thank you, Boy.
Yeah, thank you so much, Paul, for that beautiful way to wrap it up. I wish we could go on and on. I would love to ask more questions, but I always know that there will be more opportunity for engagement and to to drive forward this conversation. Let me use this opportunity on behalf of SPESA and the organizer of this of the forum of FIFA to thank all our panelists, Ololade Shylon from Facebook, Maxwell Kadiri from Open Society Justice Initiative, and of course, Paul from SPESA. And I think especially to thank Commissioner King for gracing this session and for giving us that beautiful opening remark, and Eva for continue from where she stopped. Kuda, thank you for making out time out of a busy schedule to still jump on the call and offer your rich perspective. My name again is Adiboye Adegoke, and I'm affiliated with Paradigm Initiative. It's been a great time moderating this conversation. I encourage all participants to join the rest of the session for the Forum on Internet Freedom in Africa, which will continue immediately after now. Thank you very much for listening, for being part of the session, and I hope you enjoy the rest of your day. I hope I can get a bye-bye from our panelists.
Thank you, Boy.
Thank you, everyone. Bye.
Thank you.